Actual causation, video one, from risk creation to realized harm. In this video, we are going to be introduced to and learn how to apply restatement, third of torts, sections 26 and 27. Negligence as a doctrine at its core is about the creation of unreasonable risk. When we look at our second element of negligence, that's breach, right? Our first element is duty. Our second element is breach. When we look at breach of duty, we are not asking if a harm has occurred. When we look at breach, we are asking whether the defendant's conduct fell below the standard of reasonable care under the circumstances. That inquiry, the inquiry about the defendant's conduct falling below the standard of care, is a behavioral inquiry. That inquiry asks whether the defendant's conduct exposed others to a probability of harm. And that probability of harm was one that was foreseeable and unreasonable as determined by what is accepted by society. At that level, negligence is about risk creation, not harm. And that is why, at that level, negligence can exist without injury. Here's an example. Let's say you have a driver speeding through a school zone at the time that the school is being dismissed. That in and of itself is negligent, even if no child is struck by the driver. The behavior is unreasonable because it generates a foreseeable and significant risk of harm, right? The wrong lies in the exposure of others to danger. Does that make sense? Take a minute and stop and think about it. But when we shift to discuss negligence liability as a completed tort claim, our focus is different, right? Tort law does not award damages for risk alone. So if we're looking at negligence as a completed tort, that requires us to evaluate the duty of care that the defendant has, whether or not the defendant has breached that duty of care. We must look at cause and fact. We must look at proximate cause, which is the scope of liability, and we must also look at damages. Negligence liability does not impose liability merely because a defendant created a risk of harm. We just said that, right? The plaintiff must show that the very risk that made the conduct negligent actually materialized in harm. In addition, the plaintiff must show that the harm occurred because of the conduct. Do you see that there's a link, right? Factual causation, also known as actual cause, also known as cause and fact, connects the defendant's conduct to the injury. Factual causation connects the defendant's conduct to the injury. In other words, causation is the hinge between risk creation and risk realization. I'll say that one more time, but I'll say it differently. Negligence as conduct is risk creation. We just talked about the vehicle speeding through the school zone during dismissal time. Negligence as liability is about risk realized in the injury. Causation is the hinge between the two. Causation is what links the risk creation to the risk realization. Okay? Actual cause asks whether the defendant's negligent conduct was a factual cause of the plaintiff's injury. That is, whether the injury suffered by the plaintiff would have occurred absent the defendant's conduct. Take a minute, write that down, pin that, highlight that. Does the injury serve as one that would have occurred absent the defendant's conduct? We call that a counterfactual question. The focus is not about risk creation. The focus is on the counterfactual inquiry. And this is the counterfactual inquiry. Would this injury have happened if the defendant's conduct was removed? Would this injury have happened if the defendant's conduct was removed? If the injury would have happened, even if the defendant's conduct would remove, actual cause fails. If the injury would have happened, even if the defendant's conduct was removed, what am I saying? I'm saying that it doesn't matter what the defendant's conduct was or wasn't. The plaintiff would have been injured anyway. When I say that, what am I getting to? I'm getting to there is no causal link. Okay? If the plaintiff's injury would not have happened if the defendant's conduct was removed, then we have actual cause, right? Causation ensures that the unreasonable risk created by the defendant actually caused the plaintiff's injury. It forces the plaintiff to demonstrate that the unreasonable risk created by the defendant is what created the injury suffered by the plaintiff. Take a minute. This is it's a lot of information, and it's better if you slow down and take it piece by piece. So I'm going to go back one slide. Ask counterfactual question. Even if the actor had not been negligent. So in the absence of the conduct of the defendant, would the injury have occurred anyway? If the answer is yes, there's no actual cause. If the answer is no, the injury would not have occurred. If the defendant's conduct was removed, you now have actual cause. Get it? We like to call the test that we apply to determine actual cause the but-for test. But for the defendant's conduct, would the injury have occurred? Now, let's look at the restatement third structure when it comes to this actual causation. Restatement third of torts, section 26, is where we find the rule of law for factual cause that's set up as the but for test. Restatement third of torts, section 27 is the rule that we use when we have multiple sufficient causes. We will be introduced to section 27 in this video. Restatement third of torts, section 28 provides us with alternative liability when we are not able to use the but for cause or the most multiple sufficient cause test. We will address 28 in the video 2. Multiple tortfeasors, that rule of law is found in the Restatement Third of Torts, section 30. The scope of liability, which we address as proximate cause, is found in the Restatement Third of Torts, section 29. And then we're also going to review the Restatement Third of Torts, section 34, which is the allocation between the court and the jury. Okay. When we move into causation under the Restatement Third of Torts, we are not merely adding another element to negligence that we need to create a box to be checked, right? We are literally entering into the structural center of negligence liability. In other words, causation is not just one more box to check. Causation is the doctrinal pivot point where the entire architecture of negligence either comes together or falls apart. The Restatement Third of Torts does something deliberate. It organizes causation into a sequence that mirrors the logical progression from risk creation to legal responsibility. Well, let's not talk about it any longer. Let's get into the rule of law. Restatement of law, third torts, liability for physical and emotional harm. This is found in Chapter 5, Factual Cause, Section 26, and here is the quoted rule of law. Tortious conduct must be a factual cause of harm for liability to be imposed. Conduct is factual when the harm would not have occurred absent the conduct. Tortious conduct may also be a factual cause of harm under Restatement 27. But for the time being, let's focus on Restatement 26. You know, I love the restatements. Number one, because it's the rule of law. I love the restatements. Number two, because they have comments. And those comments will oftentimes define and explain for you how that rule of law is to work. And the third reason that I absolutely love the restatements is because they provide illustrations so that you can see how that rule is actually applied with real people in real life situations. Let's take a moment and look at comment B. That does not mean that you should skip comment A, but for the video, I want to highlight comment B. And what I'm highlighting is the but for standard. Okay. I'm highlighting the but for standard. The standard for factual causation in this section is familiarly referred to as the but for test. Also, Latin sine qua non test. Both express the same concept. An act is a factual cause of an outcome if the absence of the act, the outcome would not have occurred. Okay. With recognition that there are multiple factual causes of an event, look at comment C, right? A factual cause can also be described as a necessary condition. So, more traditional verbiage is going to set actual cause and its test up as a but for test. But if you see the necessary condition test, we're speaking about the same test. Okay. An act can also be a factual cause in accelerating an outcome. I'm going to leave you to read that because some of your practice questions are asking you about accelerated outcomes. It's your responsibility to know not only the rule of law, which is found in the restatement, but also the information that is provided in the comments. Let's take a look at comment C. Comment C says tortious conduct need only be one of the factual causes of harm. Pay attention, this is going to trip someone. Comment C says tortious conduct need only be one of the factual causes of harm. So, an actor's tortious conduct need only be a factual cause of the plaintiff's harm. The existence of other causes of the harm does not affect whether the specified tortious conduct was a necessary condition for the harm to occur. I know that you've read all of these cases already, so I'm sure this is already making sense. So, without any further delay, let's apply the restatement third of torts, section 26. And we're going to apply it to the Perkins v. Texas and New Orleans Railroad Company case. Now, for my morning, Monday, Wednesday, Friday class, we've already had this discussion on Friday of last week, right? We had this discussion already on Friday of last week. But again, so that there's not any gaps in how the doctrine is being provided, let's talk about Perkins v. Texas one more time. Let's talk about Perkins v. Texas one more time. If you remember, the Perkins case is the case that concerns whether the Texas and New Orleans Railroad admitted negligence of operating their train at 12 miles per hour over the internal safety limit was the factual cause of a fatal collision. Okay, remember, overview, we've got a vehicle, we've got a train, there's a collision, the people in the vehicle, the driver and the passenger, both die as a result of the collision. And the widower, the widower of no, the widow, I'm sorry, the widow of the passenger sued the Texas and New Orleans Railroad Company. Well, let's see what took place. If you remember procedural history, the district court imposed liability on the railroad. The appellate court for Louisiana affirmed the district court's holding. The Louisiana Supreme Court reversed. Take a minute to remember. Let's look at the issue statement. I wrote it in three parts. Again, just as a good habit of framing the issue. Under the restatement third of torts, section 26, that's our rule of law. Here's the legal question that has to be answered. Does a railroad's operation of a train at 37 miles per hour, which is in violation of its 25-mile per hour safety rule, does that serve as a factual cause of a passenger's death? Am I done? No, right? Because just because I'm going 12 miles over a safety rule, does that serve as the factual cause of a passenger's death? Well, right, that doesn't capture really the critical issue of Perkins. What's the critical issue? When the automobile carrying the passenger was already on the track, when the train first had visibility of the car, right? And the evidence did not establish that traveling at the lawful speed would have averted the collision. So, in other words, what's the issue? Well, we've got a couple that are really connected. We've got a train that's going to concede they were going 12 miles over what their safety rule prescribed. Their safety rule prescribed 25 miles per hour. The train, the defendant, is going to concede they were going 37. So they're 12 miles over, right? Right. There's a collision, right? Right. Is the fact that the train was going 12 miles over the safety speed the factual cause for the injury suffered by the plaintiff? Well, we've got some competing facts. What are those competing facts? One competing fact is that the automobile that was carrying the passenger had come upon the track in front of the train before the train had any visibility because of a warehouse structured on the rail yard, right? So that's problem number one. And problem number two, we have a fact of an expert witness that says even approaching at 25 miles per hour, which is the safety speed for the train, there's no indication that the train would have been able to stop in time. So, in light of those facts, does the fact of exceeding the safety speed by 12 miles per hour serve as the factual cause of the passenger's death? That's our issue statement. I showed this to you on Friday. So I'm good at some things. I'm not great at other things, but understanding that sometimes if we can see the action, it's easier for us to evaluate the action. And so what we have is the train in blue, remember? So let's talk about the crossing condition first. Here's some facts. The crossing condition is blind. Why? Because there's a 500-foot warehouse that sits where it sits so that the train has a blind spot, as does the traffic that's going from the north to the south, which was the direction of the vehicle. That's represented by the orange box and the orange arrow. The train was proceeding from west to east, as represented by the two blue blocks and the blue arrow. Now, again, remember, the train had 113 cars attached. Okay. The train crew, knew of this warehouse obstruction, as did the driver in the vehicle. Now, as the train approached this intersection, they had their lights on. It was right before dawn. It was a little bit, no, it was right after dawn. It was a little bit after 6 in the morning. So we've got the sun. But mind you, the train's going east. The sun rises in the east. Okay. But the train crew knew about this obstruction, as did the drivers in the vehicle. Okay. The train, the 113 car freight train, traveling at 37 miles per hour. The internal safety limit was 25 miles per hour. They concede that they were 12 miles per hour over. Got it? At 37 miles per hour, we have testimony that is going to take the train 1,250 feet to come to a complete stop. What do we know about the automobile? We know that the automobile is merging from behind the warehouse. We know that the front wheels had already come across the north rail, right? So the car was trying to beat the train, right? Once the tires of the truck crossed the top of the rail, the train was 30 to 60 feet from the crossing, right? The speed of the automobile, we don't know. We don't know how fast they were driving. Again, the driver and the passenger was deceased. Before the driver died, the driver conceded that he too was negligent in trying to cross before the train. So we've got two parties that concede negligence. We have a collision, and we have the both parties in the car deceased. Got it? Got the visual? Perfect. What is our rule of law? Restatement third of torts 26. What does restatement third of torts 26 say? An actor's tortious conduct is a factual cause, because we're trying to find out here. We're trying to find out if the train's actions, if the train's tortious conduct, right, which was negligent in its risk creation, right? Not liable, but negligent in its risk creation. We're trying to find that out. We're trying to evaluate if that is the factual cause of the harm of the passenger who died as a result. This is a but for, or if you want to refer to it as, a necessary condition test problem, right? This is a but for, or necessary condition test problem. Now, be mindful. The conduct of the defendant does not need to be the sole, SOLE, cause. Be mindful. Number two, the plaintiff bears the burden by a preponderance of the evidence. What does that mean? That means that the plaintiff has to show proof that it is more likely than not that the harm would have been averted absent the negligent conduct of the defendant. So this burden is on the plaintiff. What do we have? At the starting point in the court's causation analysis, right? We have them starting at a place of, we're not trying to determine if the railroad was negligent in conduct. We know that they were negligent in conduct, right? That issue's resolved. They were negligent in their conduct, in their risk creation, because they were traveling 37 miles per hour in violation of its own 25-mile-an-hour safety regulation. So whether they had a duty, not a question. Whether they breached their duty, not a question, right? They set the standard. They, being the railroad, set the standard at 25 miles per hour. They, being the railroad, violated the standard by traveling 37 miles an hour. So there's no question. Was there a duty? Clearly. Was there a breach? Clearly. All right. And then if you want to throw in that we have a blind spot, we know about the blind spot, right? There's no question that the element of duty and breach are both satisfied. Great. So what's left? We're done, right? No, we're not. Breach alone, right, does not establish liability. Those were the first couple of slides of the video. Breach alone is not enough to establish liability. What do we need? We need the causation link. Okay, how do we get that? We get that with the counterfactual inquiry. What's that? That's the but for test inquiry. Oh, okay. So how does that work? The court reconstructed a lawful world. And this is what they did, right? This is counterfactual. In the reconstructed world, the train's not traveling 37 miles per hour. The train's only traveling 25 miles per hour because that is the conceded safety speed, right? And so here we go. Here's the question. Ready? If the train had been traveling at 25 miles per hour, in other words, if we remove the negligent conduct of the train, would the fatal collision have been avoided? Let's see what's going on. The record revealed that we've got a brakeman on the train and we've got a fireman on the train, in addition to the engineer. Okay. When the brakeman and the fireman first saw the automobile emerge from behind the warehouse, the automobile's wheels were already crossing the railroad track. If we could freeze time at that moment, the front tires of the car are coming over the track. The brakeman and the fireman see the automobile freeze. At that moment, the train only had 30 to 60 feet before it got to the car, before it got to the crossing. Okay. Even though the train triggered their braking system at 37 miles per hour, we have expert testimony that says, I know you only had 30 to 60 feet to stop from the time that you saw them, but at 37 miles per hour, you would have needed 1,250 feet to stop. Here is the fact that made the difference. Pursuant the testimony of the expert, even in reducing the speed to 25 miles per hour. So in other words, if the conduct had not been negligent and if the train was traveling at the rate of speed that was deemed safe, which is 25 miles per hour, they still would have needed more than 30 to 60 feet to stop. They would have needed more than 30 to 60 feet to stop. What does that mean? That means that the train, even if going the quote unquote safety speed of 25 miles per hour, that collision would have occurred anyway. The collision would have occurred anyway. All right. But we don't stop there. We don't stop there, right? We don't stop there because the automobile was also moving. The court considered whether the automobile may have cleared the crossing if the train had been traveling even slower than 25 miles per hour, right? Because maybe the problem, we hear this in the dissent, maybe the problem isn't 37 miles an hour, which is 12 miles over. Maybe the problem is 25 miles an hour may still be too fast, right? May still be too fast. And so let's see. With our expert, the evidence failed to establish that the automobile speed with any certainty, right, would have been able to clear what they call the danger zone at any rate of speed, even a rate of speed below 25 miles an hour, right? So in addition, there was no evidence that the passenger who died, and it's the passenger's widow who's bringing this lawsuit, there's no evidence that the passenger, clearly having seen the train coming, there's no evidence that the passenger attempted to exit the vehicle. And there's no evidence that the driver attempted to slow the speed of the car, right? So we've got some missing facts. And if we don't have facts and evidence, well, what does that mean? That means that those facts don't get considered. Now, the plaintiff's theory rested on this proposition. The plaintiff's theory rested on the idea that a reduction in speed of the train might have given the driver and the passenger in the vehicle additional time for evasive action, right? So the widow is saying, yeah, I hear what you're saying. However, if the train were going slower, even if that would not have been enough for the train to stop in the amount of distance that it had before the collision, had it been going slower, the driver and the passenger may have had more time to make evasive measures, right? The Supreme Court rejected that argument as conjecture. Why? The plaintiff bears the burden of showing by a preponderance of the evidence, that is more likely than not that the injury suffered by the plaintiff would have been avoided but for the negligence of the defendant. In the case before us, the evidence did not demonstrate that traveling at 25 miles per hour would have prevented the collision. To the contrary, the circumstances suggested that the automobile was already in position of peril when first observable at the collision, and that the collision was effectively inevitable. Yeah. So what do you have? Because the record did not support a finding, right? Because we're in the appeals process, right? The trial court ruled for the plaintiff. The appeals court of Louisiana affirmed that ruling, went up to the Supreme Court of Louisiana, and the appeals court can only look at what's in the record. The Supreme Court, which is an appeals court can only look at what's in the record. And from reviewing the record did not support a finding that the excessive speed was a necessary condition of the fatal injury because the collision appeared almost certain to have occurred, even at a lawful speed. The railroad's negligence was not a but for cause under Section 26, right? The counterfactual world looked material the same as the real world, according to the factual causation, right? Accordingly, factual causation failed. What's the counterfactual world? Counterfactual world, we remove the negligence of the defendant. So let's say that the defendant was going 25 miles an hour, which was the safety speed, right? Would the injury still have occurred? It's more likely than not, yes. If the injury would have occurred in the absence of the defendant's negligence, we don't have actual cause, which means the defendant is not liable. Got it? That pause was intentional. Wanted to give you a time to kind of run it back through your brain. The rationale of the majority is this: the court's reasoning rests on three structural principles. One, negligence alone is not actionable, right? Because we're not just looking at risk creation. The risk creation must be linked to the injury. Causation requires probability, not possibility, right? The plaintiff's presupposition that if the train were going at 25 miles an hour, the driver and the passenger may have had more time for evasive maneuver is not reaching the legal standard of more likely than not, right? Now, we've got a dissent. And Justice Hamlin's dissent focuses on how dangerous the crossing was. Justice Hamlin is saying, look, let's use our common sense. We know about the blind spot that's caused by the warehouse. We know that the train was more than a mile long. So it was going to take considerable distance to stop if it needed to stop. It had 113 cars. The railroad people who were responsible for the train had to know the hazard, right? They are the brakeman, the fireman, and the engineer of the train. So this can't not be information that they knew. And they entered the town 12 miles over their own safety standard. So, in Hamlin's perspective, the excessive speed increased the danger at an already dangerous crossing, right? So, we've already got a dangerous situation. The behavior of the railroad increased that danger. All of that's right. All of that's right, right? But the majority took a much stricter approach. The majority said, yes, the behavior, the conduct of the railroad was negligent. Again, they created a foreseeable, unreasonable risk. But we know that the creation of an unreasonable risk alone is not enough to support liability. The plaintiff must prove, right? The plaintiff must prove by a preponderance of the evidence that It is that unreasonable conduct that resulted in the injury, and it has to be probable, not just possible. So, the real question, if the train had been going 25 miles an hour instead of 37, would the collision have been avoided? The evidence didn't show that it would have been avoided, right? We already talked about it. The car was already on the track when they were first seen by the train. The train was only 30 to 60 feet away at that moment. And even at 25, according to the testimony of our expert, the train would not have been able to stop in time. It's kind of the end of the story. Yeah? Want to think about it? The but for causation is not diluted by concurrent negligence. We've got driver negligence, right? Does not eliminate the need for proof against the railroad. The burden is on the plaintiff. And just because risk was created, that does not equal risk realization, right? Speeding created the risk. The created risk does not equal risk realized. That's the test. Okay. All right. Let us find our takeaway here, and then we can move to the next case. Under the restatement third 26, negligent conduct must be a necessary condition of the harm. In this case, the court concluded that even without, this is the Supreme Court, of course, even without the excessive speed, the collision would have still occurred. That's the Perkins case. Got questions about it? Write it down, work it through, go through the case. And if it still doesn't work itself out via the doctrine, let's have a conversation about it. So, moving from Perkins and Restatement 30 towards Section 26, let's pivot now to multiple sufficient causes. We are going to pivot now to multiple sufficient causes. Up to this point, factual causation has been governed by the but-for test. This is where class ended on Friday of last week. But-for test, an actor's conduct is a factual cause of harm if the harm would not have occurred absent the conduct. In most cases, that framework works, and it works pretty cleanly, right? Remove the negligent act of the defendant, and if the injury disappears, we've got a link. If the injury doesn't disappear, we don't have a causal link, right? So let's then ask a harder question. What do we do when we have multiple sufficient causes? What do we do when we have multiple sufficient causes? This is the lecture that we would have had yesterday. That's Monday, February 23rd. So imagine two actors acting independently of each other start a fire. Either fire alone would have been enough to burn down the plaintiff's house. The fires merge and destroy the plaintiff's property. Now, let's apply a but-for test to that situation. We've got two fires right? Because we've got two actors. They're acting independently. And whatever it is they're doing, they are negligent in their fires. Okay. We're going to call one fire fire A, and we're going to call the other fire fire B. If we remove fire A, that's the counterfactual world of the but for test. If we remove fire A, the house still burns down because of fire B. So, what does that mean? That would mean that A is not a factual cause. Remember, if you remove the negligence of the actor and the damage would have occurred anyway, that means that the negligence of the actor is not the causal link, is not the factual cause. So if we remove fire A and their negligence, the house still burns down because of fire B. Oh, well, let's flip it and let's see what happens the other way. If we remove fire B, the house still burns down because of fire A. Wait, hold on a second. Because if that's what we have, what just happened? Under the mechanical but for analysis, neither fire appears necessary as a condition to the construction, right? 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 Did you see what just happened? I've got two actors who are independent, who start a fire, and they're negligent. That fire, either one of them alone, would have been sufficient to burn down the plaintiff's house. Somehow, the two separate independent fires merge and they destroy plaintiff's property. Plaintiff wants to sue. Plaintiff has the burden of establishing factual cause, which is the negligence of the actor, the defendant, right, is the but for cause of the harm. So plaintiff's going to have to come in and say, but for A's negligence in that fire, my house would not have burned. Well, it would have because of B. So if the harm would have occurred with the absence of A's fire, then A can't be the factual cause. That's the but for test, right? And then we vice versa. If we remove fire B, and if the house still burns because of fire A, that means that B can't be the but for cause, right? So if we use that mechanical but for analysis, neither fire appears to be a necessary condition. What do you think about that? Well, that's got to be unacceptable, right? That's got to be unacceptable because that means that neither A nor B is going to be responsible for the plaintiff's burned down house when both A and B sufficiently on their own were enough to burn down the house. Well, how do we solve a problem when there's multiple A and B, sufficient, both of them being sufficient causes? What do we do? Restatement, third of torts, section 27. Restatement, third of torts, section 27 states, if multiple acts occur, each of which under section 26 alone would have been a factual cause of the physical harm. At the same time, in the absence of the others, right? Each act is regarded as the factual cause. So let's go back a slide. If we only had fire A, and if we removed fire A, if that outcome of removing fire A would have resulted in plaintiff's house not burning down, we know that A is not the actual cause, right? Right? Or A is the actual cause if we remove it, right? So A alone will down plaintiff's house. B alone would have burned down plaintiff's house. If multiple acts occur, each of which under 26 alone would have been a factual cause of the physical harm, right? Then what that means is that each of those acts are going to be regarded as the factual cause of the harm. In other words, you can have more than one factual cause. Okay. Comment A, multiple sufficient causes generally. Again, we've got the rule of law from the restatement, and what the restatements do so beautifully consistently is they give us an explanation of what the rule of law is. Comment A, this section applies whenever there are two or more competing causes, each of which is sufficient without the other to cause the harm, and each of which is in operation at the time that the plaintiff is harmed. Get it? When an actor's tortious conduct is such a cause, it nevertheless would not be factual cause if factual causes were limited to the definition in Restatement Third of Torts, Section 26. Even without that tortious conduct, the harm would still have occurred because of the competing cause. So make sure that you're reading your restatement, and make sure that you're reading your comments. Now, I reprinted for your convenience the illustration from the restatement. Again, love the restatement. Everything you need is there. Rosaria and Ventino were independently camping in a heavily forested campground. Each one had a campfire, and each negligently failed to ensure that the fire was extinguished upon retiring for the night. Sorry, my throat is. Due to unusually dry forest conditions and a stiff wind, both campfires escaped their sites and began a forest fire. The two fires, burning out of control, joined together and engulfed Centurion Company's hunting lodge, destroying it. Either fire alone would have destroyed the lodge. What does that mean? That now means that each of Rosaria's and Vincenzo's negligence is a factual cause of the destruction. Get it? I went through that very slowly and very methodically and very deliberately because I wanted you to go through it very slowly, very methodically, very deliberately. Understand, Section 27 of the Third Restatement of Torts does not replace the but-for test. It supplements the but-for test only in the specific logical breakdown. Here it is. When but-for reasoning fails because each cause standing alone was independently sufficient to cause the plaintiff's harm. Narrow window. Get it? Narrow window. Here's an important limitation on restatement second of tort 27. Not all multiple causes qualify for application of section 27. Section 27 applies only when each cause alone would have produced the harm. Each cause alone would have produced the harm. That's when we use 27. Now, we're going to do the Hill v. Edmonds case, not because it is a restatement section 27. We're going to do the Hill v. Edmonds case because in 1966, it was the predecessor of restatement third of tort 27. Okay, so we're going to do Hill v. Edmonds because it was the predecessor of restatement third of tort 27. And then we're going to do the Anderson case, which is the case that gives the perfect example of restatement third of torts 27. And then we're going to be done for this session. Here's the overview. On a stormy night, a tractor trailer was left parked without lights in the middle of a roadway. Just give me one moment. On a stormy night, a tractor trailer was left parked without lights in the middle of a roadway. A car carrying the plaintiff as a passenger collided with the rear of the tractor trailer that was left in the middle of the roadway with no lights. The Supreme Court, remind you where you are. The Supreme Court in New York is the trial court. So the first ruling that we're going to have is going to be from the Supreme Court. But remember, the Supreme Court in New York is actually the trial court. Okay? So the Supreme Court judge, that's the trial court in New York, dismissed the plaintiff's claim against the tractor trailer owner. And the judge of the Supreme Court did that because the judge concluded that the driver of the car was negligent and was solely responsible for the accident. All right, you get what happened? We have a tractor trailer in the middle of the road, no lights, so you can't see it. We have a car being driven by the defendant, and the car that's being driven by the defendant is carrying the passenger. The car being driven by the defendant runs into the tractor trailer. The passenger in the car gets injured. The passenger sues the owner of the tractor trailer who left the tractor trailer in the middle of the road with no lights. Well, the trial court made a decision. The trial court dismissed the plaintiff's case, saying that the tractor trailer owner had no liability because the driver of the car that ran into the back of the tractor trailer was solely responsible for the accident. Okay. The plaintiff appeals. It goes to the Intermediate Appellate Division, and the Intermediate Appellate Division reversed the dismissal. The Intermediate Appellate Division held that even if the driver of the car with a passenger was negligent, right? Even if the driver of the car with the passenger was negligent, the unlit tractor trailer could still have been a causal factor as well. So even though the Hill v. Edmonds case predates the application of Restatement Third of Torts 27, we put it in here because I wanted you to see that there can be more than one actual cause. Okay. So the Intermediate Appellate Division reversed the dismissal of the Supreme Court, which is the trial court. The Intermediate Appellate Division ordered a new trial. It goes up on appeal, and the Court of Appeals, right, which is the Supreme Court, affirmed the appellate division's reversal. Get it? Got it. I'm a passenger in a car. The driver of my car runs into the back of a tractor trailer. I get injured. I'm suing the owner of the tractor trailer that left their trailer in the middle of the road with no lights on. I take my case to trial in the trial court, which is named the Supreme Court in New York. And the court in the trial court dismisses my case and says, young lady, the person who was negligent was the driver of the car that you were in. And that person was so negligent, right? So the tractor trailer owner couldn't be negligent. We've already determined, based upon the record, that the driver of the car that you were a passenger in was negligent. So I'm going to dismiss the case. The plaintiff appeals to the appellate division. The appellate division reverses. The owner of the tractor trailer appeals to the appellate court in New York, which is actually the highest court in New York. And the highest court affirmed the reversal that was implemented by the appellate division, which ordered a new trial. Here's the issue statement. Under Restatement Third of Torts 26 and 27, should a defendant who negligently leaves an unlit truck obstructing a highway be treated as a factual cause of a collision when evidence is presented that another driver's negligence also contributed, right? And we know what the ultimate answer is. Well, if once we apply the test and the test show go forward, we go forward. So let's look at the relevant facts. What's going on in this one? Let's look at the truck owner. This is the tractor trailer owner. The tractor trailer owner parked the tractor trailer in the middle of the road. No lights, stormy conditions that night, and the vehicle, the tractor trailer, was left obstructing a travel lane. Okay, let's look at the driver of the car. The driver of the car testified, this is the car that the passenger was in. The driver of the car testified she was that she saw the truck, that's the tractor trailer, 4 car lengths ahead. So you're thinking, if the driver of the passenger saw the tractor trailer 4 lengths ahead, she had time to not run into the back of the tractor trailer, right? Well, and she testified that she had time to not run into the back of the tractor trailer. The driver of the car that the passenger was in also testified that she did not know exactly what happened. She remembers swerving and losing consciousness. That's all she remembers. She remembers she saw the tractor trailer. She remembers she saw the tractor trailer in enough time to avoid the tractor trailer. She remembers that she swerved and then she woke up later because she was unconscious and she doesn't know what happened. Yeah? All right, let's look at the rule of law. Let's look at what's going on in 1966. In 1966, this situation was called concurrent negligence. Concurrent negligence happens where 2 separate acts of negligence combine to produce directly a single injury. Each tortfeasor is responsible for the entire result, even though his act alone may not have caused it. You see it? Concurrent negligence. Now, concurrent negligence does not require each negligent act be independently sufficient. This is why it's different than Restatement Third of Torts 27. Concurrent negligence does not require that each negligent act be independently sufficient to cause the plaintiff's harm. Concurrent negligence only requires that each negligent act operate as a factor. If both negligent acts are necessary components of the causal sequence, both actors are going to remain liable. Now, you can probably see that gets sticky, right? That gets sticky. It gets sticky right here. Let me show you. Concurrent negligence does not require each negligent act be independently sufficient. It only requires that each negligent act operate as a causal factor. Long time ago, we called that substantial factor. We don't exercise that doctrine any longer. Get it out of your head. We, common law, do not exercise the doctrine of substantial factor any longer, right? That was concurrent negligence. That was 1966. That's why this case is in here. So I can show you where once upon a time that doctrine lived. Today, that doctrine does not live. Today, what we have is Restatement Third of Torts 26. So let me stop. Today, under the Restatement Third of Torts, actual cause is determined by the but-for test, period. Actual cause is determined by the but-for test, period. Now, under 27, if I have a situation where I've got multiple negligent acts that combine to cause one harm, and each of those acts would have been sufficient in and of themselves. That means that each of those acts by themselves would have satisfied the but for test under 26. If that's the case, very, very narrow provision, remember. If that's the case, I now have a situation where all of those multiple negligent acts that combine that would have been sufficient on their own to cause the plaintiff's injury, all of those acts are considered factually the cause. Take your time, rewatch the video. Let's get through Anderson, and that is going to give us enough content for Monday, and for last Friday, and that's going to give us enough content for Monday. And if you are in my evening class, that's going to give you enough content for what we would have covered yesterday in class and what we would have covered tomorrow. This way, making sure nobody's missing anything. Okay, let's go over our last case. This is Anderson versus Minneapolis. Wait, is that right? Yeah, okay. This case concerns, here we go. The overview of the Anderson case is that it concerns whether a railroad, here's another railroad, may be held liable when it's negligently set fire, right? Railroad negligent set a fire. That fire combined with a second independently set fire to destroy the plaintiff's property, even though either fire alone would have been sufficient to cause the destruction. Got it? Minneapolis Supreme Court held that the railroad could be liable despite the presence of another independently sufficient fire. Get it? Independently sufficient. This is the paradigm case for multiple sufficient causes. Let's take a look at the issue statement. Under the restatement third of torts, that's my ruling law, should a defendant's negligently set fire be treated as a factual cause of property damage? That's the question. Should it be treated as a factual cause of property destruction when a second independently sufficient fire combined with it to destroy property, producing a single injury? Got it? Yeah? Taking a look. What do we have? Should we hold the railroad as the factual cause for property destruction when the railroad was in fact negligent? That negligence led to a fire that combined with another fire that destroyed the plaintiff's property. Should the railroad be held and identified as the factual cause when it combined with an independent fire that it had nothing to do with, negligent or otherwise, right? But by itself, this other fire too could have been independently sufficient to serve as the factual cause. Let's look at our relevant facts. We've got the setting. The plaintiff owned property near the railroad's right of way. Weather conditions were dry and conducive for fire set. The fires were present in the area. So we've got some fires burning already. Okay. Had nothing to do with the railroad. The fires that are burning already had nothing to do with the railroad. The railroad negligently caused a fire along its tracks. Evidence suggested that sparks from the train ignited this dry vegetation, right? And the fire spread toward the land. Okay. Talked about the second fire. The separate fire was already burning nearby. The origin of the second fire was not attributed to the railroad. It was independent of the railroad's negligence. And the second fire was advancing toward the plaintiff's property as well. You have the convergence. The two fires merged before reaching the plaintiff's property. And after merging, they combine and they burn down the plaintiff's property. Evidence established that either fire, standing alone, had sufficient size and intensity to destroy the plaintiff's property by itself. Okay, what was the holding of the court? The Minnesota Supreme Court held that the railroad could be held liable for the destruction of the plaintiff's property, even though a second independent fire would have been sufficient to destroy the property by itself. In other words, were two independent fires converged and each alone having been sufficient to cause the destruction, the negligent actor whose fire was one of the converging causes remains a legal cause of the harm. The presence of another independently sufficient fire does not relieve the defendant railroad of liability. Get it? But for logic cannot defeat responsibility. But for logic cannot defeat responsibility. Here, the railroad argued, look, even if it negligently caused one of the two fires, the other fire would have destroyed the property anyway. And because the other fire would have destroyed the property anyway, the railroad argued that its negligence was not the actual cause of the plaintiff's property destruction. Yeah. The court rejected that reasoning because that would lead to what the court called an absurd result. If two sufficient fires destroy property and each alone would have caused the loss, under strict but for logic, neither would be considered a cause. That means no one is liable, and the court refused to allow causation doctrine to collapse into formalism. So, but for logic cannot defeat responsibility. Here's the second point of the court's rationale. Each independently sufficient force is a factual cause. The court reasoned that when two independent forces are actively operating and each is capable of producing the harm, each force is a cause of the resulting destruction. The fact that one alone would have been sufficient does not negate the causal contribution of the other. Each fire materially participated in producing plaintiff's loss. Court's rationale, point number 3, fairness and responsibility. The court emphasized that a negligent actor should not escape liability simply because another force was also capable of causing the same harm. Otherwise, defendants would avoid responsibility whenever another sufficient danger existed. The law does not permit negligent actors to benefit from the coincidence of another destructive force. The court's rationale, number 4, prevention of doctrinal breakdown. The court implicitly recognized a structural problem. What's the structural problem? Here it is. Strict necessary condition reasoning fails in this situation. Strict necessary condition, that strict but for reasoning, fails in this situation. If removing either fire still leaves destruction, neither of the fires appear necessary. The court adopted a rule that preserves accountability in cases of multiple independent sufficient causes, and that rule was later recodified as Restatement Third, Section 27. Got it? So, with that being said, what is the doctrinal takeaway of the Anderson case? Anderson teaches one rather narrow but critical proposition. When two independent forces are each sufficient to cause the harm and both are operating at the same time of destruction, each is treated as a factual cause. When two independent forces are each sufficient in themselves to cause plaintiff's harm, and both are operating at the same time of destruction, each is treated as a factual cause. Make sense? Right? We went rather slow, and that was that was totally due to me. But hopefully, with that, we see that Anderson fits the structural sequence of our last hour and 28 minutes, right? We've shown risk creation is connected to our breach. We've shown that but for causation comes under Restatement Third of Torts 26. We've shown concurrent negligence, right? And the logical breakdown of the but for test. And then we've shown multiple sufficient causes, which is Restatement Third of Torts, Section 27. Yeah. Here's a framework. We like steps. Here's the doctrinal arc. We start with Section 26, third restatement. That's the but for. Did the conduct, that's the negligent conduct of the defendant, make a difference? Was it a necessary condition? If the but for test works, then I'm done. Right? If the but for test gives me a yes, or if the but-for test gives me a no, I'm done. But if the but-for test fails, because each of two independent causes were sufficient in and of themselves, then and only then do I apply restatement third of torts, section 27. Caveat, don't expand section 27 beyond its narrow purpose. And with that, that is the end of video 1, actual causation, restatement third of torts, sections 26 and sections 27. The next video will address sections 28 and sections 29. Thank you, guys. Take care. I will see you soon.